Hi, folks. My name is Greg McLawsen. I'm the Affidavit of Support lawyer. I represent plaintiffs in actions to enforce the USCIS Affidavit of Support in federal litigation, and I serve as a consulting expert when the Affidavit of Support is enforced in the context of family law cases. Today, we're going to talk about who it is who has rights that can be enforced under the Affidavit of Support. At its most basic, this is pretty simple. Basically, anybody who A, got their green card through a family member, and B, has income below 125% of the poverty guideline, that's about $1,400 per month, potentially has rights that can be enforced under the Affidavit of Support. So number one, green card through a family member. And number two, income that is below 125% of the federal poverty guideline. So let's kind of go through each of those requirements and then kind of put a little bit more detail into the picture about who has rights under the affidavit. So number one, sponsorship through a family member. The Affidavit of Support is required in virtually all family-based immigration cases. Technically, it's required in order to overcome what's called public charge inadmissibility. And the basic idea here is that it has long been the case under US law that you can't immigrate to the United States if you are determined likely to become a public charge. That means dependent on public resources. So since 1996, in virtually all family-sponsored cases, there are very limited exceptions. The petitioning family member has to sign a binding affidavit of support, basically promising to be something like a financial guarantor for the immigrant. So again, in all family-sponsored immigration cases, this is a petition by a spouse, so husband, wife bringing over their spouse. It's signed in fiancé petitions, and then petitions filed by parents or by siblings or by children. Anytime you have a case, whether it's a visa case, somebody coming in from outside of the United States, or adjustment of status, changing from a temporary to a permanent residency here in the United States, the affidavit of support has to be signed. If it's not, the intending immigrant is automatically inadmissible on public charge grounds. Now, you can also have an additional sponsor, sometimes called a joint sponsor or a co-sponsor, who also signs an additional affidavit. This happens if the primary sponsor doesn't have adequate income or financial assets. In that case, an additional person can step in and sign another affidavit of support. In that case, there will be both the primary sponsor, who is the visa petitioner, and also a joint sponsor. Now, there are a few exceptions. They primarily relate to folks who have extensive work history in the United States. If you have more than 40 quarters of work history in the United States, an affidavit of support isn't required. But just speaking on a broad level of generality, if you have a family-sponsored case, if you have somebody who got their green card through a husband or wife, or came as a fiance, you can say with almost 100% certainty that the affidavit of support was executed. So that's requirement number one, is that the person have come on a family-sponsored immigration status. Number two is that in order to have financial rights under the affidavit of support, you must have income below 125% of the federal poverty guideline. Currently, in 2022, that's $1,400 per month for a household of one. Why is this a requirement? The sponsor's obligations under the affidavit of support, which is a binding financial support obligation. Sorry, I'm just looking at a live question here. Yes, happy to talk about transferring quarters of work. I'll get to that in a few minutes. Hang with me. Where was I? So the financial obligation of the sponsor is to maintain the income of the sponsored immigrant at 125% of the federal poverty guidelines. That's where you get the 125% figure. So that is the core legal obligation of the sponsor. Make sure that immigrants' income is at or above 125% of the federal poverty guideline. So conversely, when we're talking about the rights of the sponsored immigrant, they have a private right of action. That's a fancy word for the ability to bring a lawsuit to enforce that obligation of the sponsor to maintain income at 125% of the federal poverty guideline. So when we talk about the rights of the immigrant under the contract, it is to compel the sponsor to bring the financial wherewithal of the immigrant up to that level that we just said was $1,400 per month. So that's when we're talking about who has rights that can be enforced in federal court. It is an immigrant who A, got their status based on family-sponsored matter, and then two, to have financial rights, you need to have income below 125% of the poverty guideline, because the nature of your legal claim is to restore your income up to that 125% level. I'm going to jump ahead just a little bit to answer somebody's question here, which is about, I think, crediting quarters of work. So the affidavit of support obligation carries on until the sponsored immigrant either has U.S. citizenship or the other main terminating event has 40 quarters of work as determined by the Social Security Act. And the Immigration and Nationality Act says that the sponsored immigrant may be credited with work quarters that are earned by the spouse during the marriage. So you can make progress as the sponsored immigrant towards that 40 quarters level through the work quarters of your U.S. citizen or U.S. resident spouse. However, big caveat, those work quarters are no longer credited to you after the marriage is terminated, because the INA, the immigration statute, says very clearly that in order to be credited, the marriage must quote, you must remain married to the U.S. citizen sponsor. So as soon as those quarters stop accruing, as soon as the marriage stops, the quarters are no longer credited. Further questions about transferring quarters of work, I will post, will catch me on the website, and feel free to submit a question there. That's probably going to get a little bit more detailed than we're able to address here. Because there's a different question probably about if you had quarters of work under, for example, a fake Social Security number, how do you transfer that work credit history? And that's really a different issue than termination of the affidavit of support obligation. When it comes to the affidavit of support and it comes to the sponsor's obligation, the obligation begins when the sponsored immigrant becomes a resident, and then terminates when the person has later acquired 40 quarters of work history. Okay, so going back to who has a claim, we've got family-sponsored resident who has income under 125% of the federal poverty guideline. In that situation, that individual can go to state or federal court and can obtain a judgment against the sponsor. And that judgment is going to be equal to the difference between that person's income and 125% of the federal poverty guideline. So you could certainly have a situation where the immigrant is currently earning income that's at or above 125% of the federal poverty guideline, but in the past had income below that amount. And that's actually pretty common when it comes to these enforcement lawsuits. A lot of times you'll have a situation where somebody really struggled for a year. A lot of my clients have been in domestic abuse shelters. And if you're living in a homeless shelter, you don't always have access to lawyers and internet for research and a computer. So a lot of times that claim will have kind of fallen by the wayside for a year or so. The person gets back on their feet, gets back into employment, and then at that point realizes that they had this year where they had no income, and that this represents an actionable claim under the affidavit of support. Someone in that situation can certainly still bring a lawsuit to compel the sponsor to pay the support that was owed that past year, even though the person later becomes employed. Claims under the affidavit of support are assessed on an annual basis. So if you were unemployed in 2021, then got a job in 2022, you can still recover support for that past year, 2021, when you were unemployed. Let's see, I'm just going to answer one more question here before we wrap it up. Okay, so this is a common question, which is whether the sponsor has to pay medical costs that are provided to the beneficiary, and that the answer is clearly no. The government has the right to recover the expense of means-tested public benefits provided to the beneficiary. So if the sponsored immigrant gets Medicaid, the government can technically go after the sponsor for those costs. I will say, I just wrote a declaration on this an hour ago. There is no jurisdiction anywhere in the United States that I am aware of that goes after sponsors for the cost of Medicaid. It just doesn't happen. But there is technically a right of a government agency to recover Medicaid expenses from a sponsor. Separately from that, people always worry about, can a hospital sue a sponsor if they provide medical care to the immigrant? And the answer for that is just absolutely no, period. There is no legal basis at all. And I know that there are hospitals out there that try to do this. I keep asking people to send me one of these bills because I've heard of folks getting this from hospitals. Hospitals will send a sponsor a scary letter that says, hey, we know that you sponsored this patient who was also an immigrant and you signed an affidavit of support. Well, there's nothing in the affidavit of support, there's nothing in the federal statute that gives a medical provider any basis to recover the cost of care from a sponsor. So that's bogus. If you have received a bill like that from a hospital and you're a sponsor, get in touch with me. I would love to see it. I think there's a potential claim against the hospital because that's just totally bogus. If you have more questions, feel free to drop them in the comments. I'm more than happy to answer them. And feel free to reach out to me on the website if you have a confidential question that you want more detailed assessment of. Happy Friday, everybody, and take care.